You want to walk through the jury instructions?
Yes, Your Honor.
Okay.
Our assistant is here. Can she join us at stage table?
Sure.
It's gonna be-
Sure. Defense has a copy?
Thank you.
I printed myself a copy from your email.
And Judge, I'm sorry.
Is there a copy for the defense, or?
I emailed them copies. I got a version from the defense last night.
A whole packet, or?
A
Just-
partial packet.
Entire packet. I believe it was, I mean, I took out any penalty phase because the
Judge,
jury wouldn't be instructed on that today.
Well, I just prepared the jury instructions that the court might give. The court can.
I'm assuming you just walked through the standard instructions,
Yes, Your Honor.
correct? I didn't.
Want to spend extra time working on penalty phase instructions if we get to a penalty phase later on. So I did
That's
all
what
of
I
the
took out.
instructions.
Okay.
So yours are identical to the state's except for the penalty
Packet-
phase?
The packet I got from the state included all of that.
But what
So
you've
I-
handed is everything except for the penalty?
And then I emailed Mr. Hunter, I also took out 3.6 key, the only one I removed. So,
Yes, Your Honor. Well, and I guess we'll discuss that during the charge conference. There
Okay.
may be some other items that need to be removed now.
Okay.
there's a lot of grammar issues, but a lot of it is directly from the standard instructions, so,
Just to be clear,
yes. No,
Supreme Court.
I didn't correct
okay,
that, yes.
All I did was download it from
Yes, I know.
Supreme Court.
Well,
I
Supreme
correct
Court's,
that.
Supreme Court says it's proper. In my book, it's proper. Whether I agree or not. Okay. Both sides are ready?
Yes.
Yes, Your
And
Honor.
I'll just go through both packets at the same time. You both have 3.1, and they look the same. Any objection?
Objection.
Okay. And you both have 3.2, and it looks identical. Any objection?
Objection.
Okay. And 7.1. It is the standard, correct, state?
Yes, Your Honor.
Okay, they look identical. Is there any objection?
No objection.
Okay. Brings us to 7.2. They look identical. Any objection?
No objection.
No objection.
Okay. We have 7.3. I believe they're the same. Am I correct?
Yes, Your Honor.
You use the standard as well, correct?
Yes, Your Honor.
No objection?
No objection.
Okay. That brings us to 5.3, conspiracy. Okay, give me a sec. I think you both have the same instruction. Any objection?
Objection.
Judge, what I sent Mr. Hunter is what he sent me, so.
Okay.
They will be identical unless he made additional changes to what I sent back, so.
Okay. I'm just making sure.
Okay.
The packet I handed the court was the packet I sent everybody
Okay.
early Sunday morning. They haven't made any other
Right.
changes.
Okay, so without objection, that brings us to 13.1, burglary.
Judge, I left the bolded language in there along with the instructions because I didn't know at that point whether there would be an affirmative defense. I think that part can come out now.
Agreed?
Yes,
Okay, we'll remove that. We don't need to give the other section either, do we? That's in conjunction. Give if applicable,
Yes.
the license
all of that,
issue.
yeah.
That can be removed as well,
Yes.
correct?
The
Agreed?
italicized language and the bold language.
I,
It's trick, fraud, deceit.
I had left it in.
Are you requesting it?
No, I don't think it needs to stay in at this
Okay,
point.
we'll remove it. Any other changes to that instruction? Otherwise, it looks like the standard. Either side.
Come from the state.
No,
Okay.
okay.
That brings us to 3.4, lesser included. Let's see.
No objection.
Okay,
Judge, I will note that I added the trespass while armed and trespass as category 2 lessers. So they're not category 1, which means that we had to allege the elements in the indictment, and the indictment appears to allege the elements of trespass and trespass while armed.
you want those?
I left it in. I don't have an objection to that.
You guys need a moment?
Let me just,
Yes, ma'am.
that's fine, no objection to leaving it in.
Okay, we'll leave those in. That brings us to 7.4, second-degree murder. Looks like the standard, and both are, of course, identical. Any objection?
No objection.
Okay. That brings us to aggravations for second degree, carrying a weapon. They look identical. It looks like the standard. Any objection either side?
No objection.
Brings us to 7.7, manslaughter. It's the standard, correct, State?
Yes, Your Honor, and I left all of the theories of manslaughter intact, based on my prior experience with the manslaughter instruction. I left every
Left it all
theory
in.
there,
Okay.
yes.
No objection.
Okay. That brings us to 3.3B, aggravation by carrying a weapon for manslaughter. It looks like the standard. Any objection?
No objection.
No objection.
That brings us to 13.3, trespass in a structure. Looks like the standard. Any objection?
No objection.
No objection.
That brings us to the instruction on principles.
No objection.
Okay.
None from the state.
That brings us to 3.6, independent act.
Judge, the independent act instruction was drafted based on counsel's opening statement. I don't think the jury's heard any evidence of an independent act. I would submit that that instruction is no longer applicable.
And disagree, and as for the instruction, there was, certainly been a theory of the defense throughout that Curtis Wainwright acted alone in this.
There's absolutely no evidence of the theory.
There's evidence in the state's case that it's a possibility. The so-called hypothesis of innocence is that Mr. Rodgers was not there.
Okay.
I And Dr. Coyne also said it was possible it was one person.
The abundance of caution, we're gonna leave it in at the defense request. That brings us to abnormal mental condition.
I'm asking to have that taken out with no mention regarding any sort of mental condition of Mr. Rodgers.
State,
Yes, Your Honor, that was placed in there based on counsel's disclosure of mental health witnesses. That can
no
come out.
objection to removing it?
No objection.
We'll remove it. Plea of not guilty, burden of proof, reasonable doubt. It looks like the standard. Any objection?
No, Your Honor.
Okay.
You're looking at this very shortened.
I think it's just because I'm not used to a font this teeny.
Yeah.
So it looks shorter, but I think it's the same one.
Oh, I'm sorry, are we on plea of not guilty? Or?
Yes, ma'am. 3.7.
Okay, I was ahead. So yes, no objection.
Okay. Now we're at weighing the evidence. Are there any that the defense thinks we don't need from 6 through 10?
I think we need them all.
State?
Judge, I'm not sure we need, 7 or 10.
Clearly testimony.
I think 7 comes in at the request of the
and 10,
defense.
Lieutenant Levin made reference to the veracity of Mr. Wright in terms of not a truth teller, and certainly he tells the truth when it's convenient to him, Mr. Helms.
There was no evidence of Mr. Wright's reputation for truthfulness in the community, which is what that one is intended to cover.
We'll remove 10. Okay. Law enforcement expert, cautionary instruction. We can remove the defendant testifying. You've already removed child witness, correct? Any others you removed in advance?
I'd have to pull up the native instruction.
I just want to make sure that there's nothing missing if either side wants it.
I didn't see any.
After
All
we
of that was removed when it was before it was sent to me.
Okay, so after we removed the defendant testifying, everybody's in agreement with 3.9? Other than your objection to number 10 being removed?
Correct.
Okay. That brings us to the defendant not testifying. It looks like the standard. Any objection?
No objection, I inadvertently did that one twice, so I think the next page is also
Okay.
3.9A.
We'll remove the duplicative one. That brings us to 3.9B, defendant's statements. It looks like the standard. Any objection either side? Okay. That brings us to rules for deliberation, 3.10. It looks like the standard. Any objection? Cautionary instruction, 3.11. It looks like the standard. Any objection?
No objection.
That brings us to 3.12, verdict. Okay. Brings us to 3.12A, single defendant, multiple counts. It looks like the standard. Any objection?
No, Your Honor.
No objection?
Oh, I'm sorry.
3.12F?
Well, just making sure we're all right with 3.12 subsection A.
No objection.
Okay, then we have 3.12 subsection F. No objection from the state.
No objection.
Okay, that brings us to 3.13, submitting the case to the jury. Any objection either side? It looks like the standard.
I think it's a little confusing at the bottom. It doesn't call for the paragraph that says during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations, and then to put A and B.
Yeah, normally it all runs together, doesn't it?
That's
It's
how
sort of
it,
like, it reads that way, but it doesn't really make sense. The exhibits will be sent into the jury room with you when you begin to deliberate. And then B is, if you wish
I-
to see any exhibits, please request that in writing.
I actually explain it to the jurors in every trial I have,
Yeah.
don't I?
Yeah.
That I send everything back I'm allowed to send back, and that's with the exception of anything that is considered a biohazard or that is a video or a disc, because there's no way for them to play those things back there. And we don't have any narcotics, so that's not an issue. And then I tell them if they want to see any item not sent back, such as those items, they just need to let us know, and we can let them come out and inspect them as long as they'd like.
Okay. That makes sense in total then, just the way it reads.
I freelance that one every time, so I think I've almost got it identical now.
I think it comes down in a native format with the A and B, and since I knew that the court would send some exhibits back as well as keep some exhibits out, I left both in.
Well, I intend to do what I always do, send everything back that I can, unless there's an objection for some reason from either side.
No objection from the state.
That brings us to the verdict form. All right, I'll give both sides a moment to walk through it if you haven't already.
No objection.
Okay. I think that completes the instructions that we need to go through for this portion of the trial, correct?
Yes,
Well,
sir.
there's the special instructions that have already been read in at some point.
Those are in the back of the packet
Right.
that I gave the court. The definition of proffer I placed in the back, as well as the special instruction regarding video recordings. So I wasn't sure if the court wanted to send those back, so I attached them to the back of the packet just in case.
Would you like me to read them again, send them back with the packet, or just not do it again? That's up to you guys.
I am comfortable with either reading it or sending it back, or both.
I
I'm gonna read
suggest
it,
sending
send
them
it
back.
I can send them back, and at the end of the instructions say that we've attached any instructions I've given during the trial.
Okay, that's fine.
Okay. And that would be proffer and the video instruction, correct?
Yes.
Correct.
Okay. All right. Anything else other than the changes that have been mentioned?
I'm sorry?
Anything else other than the changes that have been mentioned to the instructions?
I can have just a moment, I was
Yes, ma'am.
to get a response, so.
Okay. And on behalf of the defense, Mr. Brazel, do you renew all your previous objections on behalf of your team?
Since day one, yes, sir.
Okay, we'll show all your objections renewed for the record.
That could be misconstrued, renewing all objections from the first hearing in this trial.
Yes, sir.
Any objection we've made since the genesis of the case.
Yes, sir. We'll show it renewed.
Okay, thank you.
And just let me know when you've gotten your response. And okay. How much time are you going to need for closing? State.
Probably 2.5 hours, Your Honor.
Okay.
Maybe as much as 3, but 2.5 may be a better estimate.
Okay. If I hand the court the amended instruction on 3.9 and 13.1.
Thank you.
I'm not quite getting the response I was looking for. If I could just reserve on asking for one additional instruction, but what's been presented. I apologize for that.
Well, Your Honor, perhaps we could take 10 minutes. Counsel could get her answer and we could.
We will take a recess momentarily.
I'm assuming we'd be taking a recess sometime between now.
Well, I was going to discuss that in a minute. How much time do you need for closings from the defense? 2 hours? Okay. And do you guys need any time to prepare?
Your Honor, in light of the few instructions, it would be nice to have a few minutes to adapt.
Defense, do you need any time to prepare, or are you ready?
I never turn down time to prepare, Judge.
I'm just wondering, I mean, it's 11:20. Maybe we send them to an early lunch.
That would be great, Your Honor.
And I'll give you time to see if you need the additional instruction, give everybody time to be ready to go right out of the gate when we come back from lunch.
It was a really long afternoon.
Well, we're going to do it one way or the other, right? And if there needs to be a bathroom break, maybe that can happen in between, at the conclusion of the state's first go at it, or at the end of your defense portion of it before the sandwich part. It gives us more opportunity to break it up logically if they need to use the restroom rather than stopping either side midstream. What do you guys think? What do you think? 1? I mean, that's long, but it's kind of early for lunch. Yeah, we can do that. What do you guys, 12:45?
That would work, Your Honor.
Take a break until 12:45?
Yes, ma'am.
Oh, okay. I was just wondering how, time-wise, the state intends to break up opening.
You know how you're splitting it yet?
You know, we have not discussed how the time split, so.
Okay. All right. Why don't we bring the jury back out? We'll tell them they'd be back at 12:45, and then if you have a special instruction, we can discuss it and where to put it. And then, if not, and everybody's ready, we can get right to it. Okay, bring them out. Please be seated. I will ask our jurors again, did you follow my instructions? Now talk about the case among yourselves with anybody else or look up any of the people or places involved. Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. We still have some things to take care of. I don't want you to sit here unnecessarily. I'm going to ask that you come back at 12:45. And please don't discuss the case among yourselves with anybody else or look up any of the people or places involved, and we'll see you then.